And thank you for all coming today. My name is Alex. I'm one of the Adult Services Librarians at the Fox Lake Library, and we're going to be having the program Basic Will and Estate Planning Part 2 on the topic of probate. And I'd like to introduce you our guest speaker, Robert Monahan. Thank you so much for coming, Robert.
Hey, thank you, Alex. And I want to say thank you to Fox Lake Library for having the program. I did one a little bit ago, about a month ago, on wills by itself, and it was really terrific. I really enjoyed it. I know, Alex, you spent some time editing it and put it up on social media, on Facebook and YouTube, and I think it's great to do that. I really enjoy doing this kind of work, so I want to thank you again, Alex, and say thanks to Fox Lake Library for having me. And I want to thank everybody for coming. I want to say welcome and congratulations. I think that these topics can be scary, and that's why I say congratulations. Facing the issues that are raised by probate and wills and trusts is difficult and distressing. And so it's important to look at them head on because it can be more distressing if you don't face them. So, so congratulations, welcome, and again, thank you to Alex. Let's see here, I have to, there we go. Where to begin? Where to begin? We know that probate is a word that scares people, and people come to see me often with the aim of avoiding it. People tell me they know they want to avoid it for their kids, but they don't always know exactly what it is. They know it involves the court, but they're not sure what it is. So today we're going to cover and hopefully demystify some of what probate is. And today we're going to have 5 sections, and they may sound like a lot of terminology, but it's not as intimidating as it may seem. The first thing is a short introduction to me. So I want to tell you who I am and why I do these presentations. Then some very sort of super basic common questions about probate. And then we're going to talk about the differences between a planned and an unplanned estate. Okay, so the way a planned estate unfolds is a little different than the way an unplanned estate unfolds. And then we're going to talk about the probate process, whether it's with a will or without a will. Testate means with a will, intestate means without a will. My hope is that after each section, we'll take a break and you can ask me whatever questions occur to you about that section. I think the last time we were on wills, and a lot of the questions that came up anticipated what was coming next, but that's A-okay. That's fine. So again, we're going to talk about me, basic common questions about probate, when you plan your estate, what that means, when you don't plan your estate, what that means with respect to probate, and then how the probate process works, whether it's testate with a will or intestate. So first, an existential question. Who am I? I'm Bob Monahan. I'm an attorney at law, and I wrote a book recently about estate planning called Estate Planning Confidence. I do these presentations, and I've been doing them a while. And my motto is that no one should be so intimidated by the law that they fail to take steps to protect their families. That's my motto, and that's the motto of my show. I have a show that's called Everyday Law that runs on Comcast 17. So again, I'm Robert Monahan. I'm a practicing attorney. I'm from Waukegan. I went to Carmel High School and graduated in 1992. I went to the University of Chicago for undergrad, and I graduated in 96. And then I went to University of Virginia for law school, and I graduated in 99. After law school, I went to New York City in September of 1999. And I worked there till January of 07. So I was there during September 11th. I was actually in Midtown Manhattan. It was quite a scene. I came out of my office building in the morning to get a coffee at Starbucks, and I looked down and you could see the Twin Towers, and one of them had smoke sort of billowing out of it. And I asked a guy on the street, what had happened. And he was like, don't even worry about it. Some jerk flew his plane into the building. It was like in New York, it's like everybody had seen it all before. But that was an unusual time to be in New York because, of course, that was something that no one had ever seen before happen. And it kind of changed the country and changed a lot of people's lives. So it was an interesting time to be in New York after September 11th. But I met my wife there shortly after that happened, and we got married, and we had our children right away. So when we had two children, I think one right after the other, within the first year being married, we had our first child, and then the second one came along 2 years later, and New York City, after having children, lost a lot of its charm. So we started talking about coming back home, and I returned home after leaving New York City in January of '07, and I started my own practice in Gurnee. I have a show on Comcast called Everyday Law. It's the law you need to know. And again, the idea is no one should be so intimidated by these things that they fail to take the necessary steps to protect their families. I've got 3 kids now. They're 11, 13, and 15. So it's practically like having 3 teenagers in the house. But I don't want anyone to feel so uncomfortable with the law and legal things that they don't take steps to protect their families. So another thing I did recently was write a book about estate planning. And again, it's important to have knowledge so that you can have confidence to approach the matter. My book, it answers 49 of the most common questions about estate planning. So in my practice, I get asked the same questions a lot, over and over again, really. So I put them in a book, and these questions are like, is this really even for me? What are the steps? What happens if I don't have one? So this is available on Amazon as a paperback and as a Kindle book. And I'll give a free consultation if you fill out this evaluation that you can find at this website, okay? So the website is http://fox-lake-probate-seminar.paperform.co. What I'm asking you actually is to fill out that evaluation form for me. What I want is to improve at doing these seminar talks. I do them a lot, and part of the love I have of doing them is hearing what people ask. On my side of the desk, planning estates, I get a lot of what my clients are curious about, but I don't always have insight into questions about what people are thinking when they don't have a plan and are not even thinking about having a plan and maybe would never consider it. What those thoughts are, I'd like to know, and I'd like to address them better when I talk to people about estate planning. So all I ask is that you sort of help me improve my presentation style, delivery, and content, and you can do that by filling out this seminar evaluation form. And if you do that, I'll give you a free consultation in my office. Part of the consultation form will let you put down your contact information. And if you do, I'll call you and we'll set up a consultation in my office. So now we're on to the meat of the subject. And the first basic questions are, what is probate? Probate comes from a Latin word, and the Latin word means prove it. And what it really is about is proving to the judge that that will is what it says it is, and that everything in it is accurate and that the formalities are followed. Probate court is a court that appoints someone to administer a decedent's estate, meaning transferring the decedent's assets to his heirs or legatees and paying off debts and taxes. Okay. So we'll talk a lot about this today, but that is the very basic essence of what we're talking about. So gathering up all the assets together, paying taxes and debts, and distributing the rest to the heirs, that's what probate's about. And we're going to talk a lot about when it's necessary, when it's not necessary, why that is, and how to go about it. So the first question that most people ask is, well, okay, so it's about gathering up assets, paying debts and taxes, and distributing the rest to heirs. How do you decide if you need it? Can we get away and not do it at all? I know people who don't do it. And there's kind of a decision tree that goes along with this. And the first question you want to ask is, was there a plan? Did the decedent have a plan in place that he wrote down, appointing who would be in charge, sort of his executor or trustee? What would happen to his assets? And was there a plan in place? And the first thing is, if there was a plan, was it a will-based plan or a trust-based plan? And if it's a will, there's going to be very likely a probate, which comes as a surprise to many people who think that if there's a will, there is no probate. However, if there's a trust, it's very likely there won't be a probate. And we'll get much more into this as we go along, okay? So the first question is, was there a plan? If there was a plan, is it about a will, in which case there will be a probate? And if it's a trust-based plan, there won't be a probate. Now, I talked a little bit in the last section about the difference between a will and a trust. And if you have questions about it, we can go over it again, but let's just wait until sort of this little section is over. This section is very short, so we'll be coming to the end very soon. If there's no plan, is probate necessary? If there's not a will or a trust in place and the decedent dies without a plan, do you have to probate his estate? And the question you have to ask if there's no plan is whether the estate has land in it or more than $100,000. And the reason you're asking that is because you may be able to administer the estate as a small estate without involving the court in a probate proceeding. So the first option is, if the estate has land in it or more than $100,000, probate will likely be necessary. However, if it doesn't have land in it or more than $100,000, you can administer the estate without a probate, but with a document called a small estate affidavit. Now, that's throwing a lot at you, and really the rest of this seminar, this lecture today, is going to hopefully elaborate all of this so you come to sort of feel comfortable with these terms. So again, just to back up a minute, what's probate? Probate is a court process where the court appoints someone to administer your decedent's estate, meaning that they gather all the assets together, pay off all the expenses and taxes, and then distribute the rest to the heirs. And then there's this decision tree, that you have to go through. Hang on. Okay. So the next section will be a planned estate, will versus trust. So do you remember the first question was, is there a plan? Was it a will-based plan or a trust-based plan? The first section is going to address that question. Is it a planned estate, will versus trust? Before we get there, I want to slow down for a minute though, and see if there are any questions about sort of the question is, was there a plan? And if there was a plan, was it will-based or trust-based? So a planned estate. So let's assume there was, and let's look at the difference between whether there was a will in place or a trust in place. Okay, so we're moving on to the next section here. I'm assuming there's no questions because the first set of slides was really just to set the table. Okay. Many people think that if you have a will in place, you don't need any probate to administer it. They think having a will alleviates you from a probate proceeding. And I'm sorry to tell you that's actually a misconception. The will that you draft is not legally effective by itself, not until it's been approved by a court. The court in probate looks at the will, determines if it's valid, and then issues what are called letters of office. And it's the letters of office that are legally, effective documents, okay? So the letters of office are legally effective documents. What does that mean? If you took your will, say you have a will and you pass away, and your son is your executor appointed in your will, and you have a bank account. So your son takes your will to the bank and says to the teller, I'd like the money in that bank account. If you can see, I have the will, and the will appoints me the executor, so I'm in charge. The bank teller will say, look, I don't care what the will says. What I want to know is, will I get out of being held liable for what happens here? And to be not held liable, I need to have a copy of letters of office issued by a court. I don't need the will. I don't want to see the will. I don't care about the will. What I want to see is something from a court called letters of office before I release 1 penny from a bank account from the decedent. Till you show me the letters of office, I don't care how many wills you show me, I'm not releasing 1 penny. So the bank teller will not release to your executor any money with just the authority of the will. The will by itself is not, like I said, legally effective. Same thing with selling property. If your son tries to sell your home after you've passed away and tells the buyer, look, you can tell I have the authority to sell this home, I'm the executor. The buyer's attorney will say, whoa, where are your letters of office? Your letters of office are what give you the authority to sell the home, not the will. I mean, the will hasn't been probated yet. How can we go through this transaction? So a will by itself is not effective. And people think they avoid probate if they have a will, and that's a mistake, okay? You remember how I said we'll talk about the difference between a will and a trust and whether you can avoid probate if you plan your estate? The difference between a will and a trust is that assets held in a trust are not subject to a probate court's authority. You think of a trust as a bowl, and it's a bowl that holds assets, and anything put in that bowl is outside of the scope of the probate court's authority. It's effective immediately upon signing and transferring assets into it. Like I said in the bottom there, it's like a bowl holding your things, your assets. And the whole reason these days many people will plan with a trust is to avoid probate. Okay, so just in addition to that topic, there's certain things that are also not subject to probate court. And in addition to assets held in a trust, jointly owned assets with a right of survivorship are not subject to probate. They pass automatically on the death of one joint owner to the other, and it's by operation of law, and the probate court has nothing to do with it. Also, beneficiary designated assets are sort of contract assets. Those include things like life insurance, 401k, IRAs, anything that designates a beneficiary passes outside of the probate court's authority as well. So let's see where we are here. Jointly owned assets, like I said, pass by operation of law. Probate court has no authority over these. However, just a caveat, be careful about using joint ownership as an estate planning tool. And many people think, well, I'll just put my son on as an owner. That way I can avoid probate of that asset when I die. He can avoid probate of that asset when I die, and he'll just become the owner automatically. Well, the issue that can arise if you put your children on a title to your assets like your home is that then it belongs to them, and there's no takebacks. If If a creditor of your son comes calling, that's an asset that your son has a one-half interest in. Or if he gets a divorce, it could become an asset in the divorce proceeding. Or if he gets in an accident and has medical bills that could bankrupt him, your house could be an asset that is part of the bankruptcy estate and could be foreclosed on and sold to satisfy his debts. So the planning with joint estate planning through joint ownership is dangerous. Beneficiary designated assets passed by contract, sort of the typical one is a life insurance policy. You agree with a life insurance company to pay your premiums. On your death, they pay an award, a benefit to who you designate. One thing for sure is that when you do plan your estate, one thing your estate planning attorney should work on you with is ensuring that you have your beneficiaries correctly designated. Okay, so let's just take a look at what we talked about. I don't know whether people are aware of what I've just said or not. The big thing was that when planning your estate, if you do it with just a will and not with a trust, it's very likely you'll have a probate proceeding. And we'll get to sort of the next part next. But before we do that, I'll take a breather and see if there are any questions about what, since there aren't any questions. And an unplanned estate. So we talked about a will and a trust, and a will probably needs to be probated. A trust does not if it's properly funded. And that's something we'll talk about a little further. Unplanned estate, probate or not. Now this depends. You might not have to probate your estate if you don't have a plan, as long as you don't own real estate, which is real property or land, and your property in cash is less than $100,000. Then you can use the small estate affidavit. A small estate affidavit is for small estates. Again, estates that don't have any land in them, and property and cash and so on is worth less than $100,000. The small estate affidavit is actually a kind of substitute for letters testamentary, which are another term for letters of office. Remember how I said that if you pass away and you have a son and he takes your will to the bank, the teller will say, hey, I don't want to see the will, I want to see letters of office. Well, if your son uses a small estate affidavit, meaning that when you died, you didn't have any land and your bank accounts and so on were worth less than $100,000, your son can go to the bank with the small estate affidavit, give it to the bank teller, tell the bank teller, look, this is for you, and I'd like to access that account and distribute it to my brothers and sisters. The bank teller can rely on the small estate affidavit, and the bank can avoid liability in releasing the funds to your son. Again, the small estate affidavit is a substitute for letters of office. I hope everyone understands that, but the small estate affidavit is a substitute for letters of office that you would obtain from a probate court. And a bank teller can rely on the small estate affidavit just like he could rely on letters of office and avoid liability. The bank teller would take those letters of office, make a copy to keep the bank, release the funds to your son, and your son has sworn in that affidavit to distribute the funds that he obtains from places like banks and brokerage accounts and so on, to distribute them to the proper heirs. If one of those heirs does not get the share of money that they should have, and they come after the bank can rely on the small estate affidavit and say, hey, he promised to do what he said, and we are absolved of liability by the small estate affidavit, and your only recourse then is to go to the son who presented the small estate affidavit and pursue him. So again, the bank is allowed to rely on the small estate affidavit, avoid liability point the finger at the son that presented it, and the heir that maybe didn't get the share he or she was supposed to get can go after the son. That's how the small estate affidavit works. But again, the small estate affidavit is only for limited circumstances where there's no home in the property, no other real estate in the property, and the property is worth less. The property outside of real estate, sort of the bank accounts, brokerage accounts, and so on, whatever there is worth less than $100,000. Otherwise, if there's land, real estate, a home, and more than $100,000 and or more than $100,000, you have to probate the estate. You can't use the small estate affidavit. You have to go to probate. And if you died without a plan and you go to probate, you died intestate. That means you died without a will. And if you died without a will, the state of Illinois has a will for you. And that will is called, the rules that govern your situation are called the rules of intestacy, okay? The rules of intestacy control who will be in charge of your estate, the administrator, how your assets will be distributed, who will be the guardian. All of this is governed by the rules of intestacy, which is basically the Illinois legislature's best guess about what should happen to your assets and your estate when you're gone. If you didn't sort of do it on your own, you leave it up to the Illinois legislature's best guess about what you would want. Okay, so that is kind of that part of the presentation. Again, if this is an unplanned estate, and whether you have a probate or not depends upon your asset situation to a degree. If you don't have real estate and your property is less than $100,000, you can avoid probate by using a small estate affidavit. Otherwise, if you don't have a plan, if you don't have a will, the state of Illinois has a will for you. It's called the rules of intestacy, and they govern your situation. And those rules are basically thought up by the legislature, and they are the legislature's best guess about what you would want if you died without a will. And the Illinois legislature is, you can rely on them if you like. It's sort of up to you, but if you don't have a plan, there's a plan in place for you, and you may feel good about that or not. It's really, I think it's better to take control of your own situation. Okay, are there any questions about that part? Because I'm going to take a little break. Are there no questions? Okay. What does probate look like? I'm going to talk about the probate process now. And we talked about it when there's a will and when there's not a will. And they look similar, but they're not exactly the same as you could probably imagine. But they do have a lot of similarities. First, if there's a will, I want to let you know you have to file it. You have to file it at the clerk's office. If you don't file it, believe it or not, it's a class 3 felony. It's a felony if you willfully secrete a will for 30 days after the death of the decedent. And that's the statute right there that lays that out, a class 3 felony. That's the same class of felony as stealing more than $500. And so do not wait, file the will ASAP, okay? Opening the estate requires certain documents, okay? Opening the estate means going to the court and asking the court to take a look at the will. So this is done, testate and intestate. I drew a little diagram here. They're both, the first step is with a petition. So you're petitioning the court. If testate means you died with a will. So you're petitioning the court to ask the court to find the will valid and to issue those letters testamentary, those letters of office to the executor, who then will act on behalf of the estate. A petition is basically a request of the court for an order. And the order will say, we have found this will valid, and we appoint Joe as the executor, and we will receive the letters testamentary, and he'll have to do everything he's supposed to do under our supervision. So that's testate. Intestate also begins with a petition. Again, you're asking the court for not letters of office, but in an intestate estate, it's called letters of administration. And who can ask for letters of administration? Remember, in a testate estate, there's a will with an executor, and it would be the executor who would do the petitioning. In an intestate estate, there's no one appointed. So there's a list of preferences over who can do the petitioning. And so it's in this order, spouse, kids, grandkids, et cetera, and so on. So both start with a petition though. So you have to ask the court to issue an order appointing either an executor with letters of office or an administrator with letters of administration in an intestate estate. The second document that's necessary in opening an estate is the oath and bond. The oath and bond is an interesting document that you have to file. The oath is what the petitioner files, saying he's going to carry out all of his duties as the executor of the estate faithfully. And he would have to post a bond, but in a testate estate, usually the will waives the bond. What that means is that the executor does not have to post a bond. You know what the bond is for? The bond is an insurance policy against the executor stealing from the estate. It's very interesting. So the executor, without a will, has to post a bond. Unless the will waives this requirement, has to post an insurance policy against his own stealing from the estate. In an intestate estate, there's an oath and bond required, and a bond is almost always required because they have to know that the administrator won't steal from the estate. Affidavit of heirship is required in both testate and intestate estates, and that lists all the heirs. Who are the people that are going to be inheriting from the decedent? And whoever is petitioning the court to be appointed either as the executor or the administrator has to swear to the court under oath that these are the heirs, and the heirs are listed in the affidavit of heirship. You can find all the probate forms online. So the probate forms are available on the circuit clerk's website, and that's here. You want to write it down, I'll pause a little bit. It's https://www.lakecountycircuitclerk.org/court-forms. Okay, it's right there. And all the forms are available there. And this is kind of how it looks. If you find this, you are in the right spot. This is the court forms right here. It goes from A to Z. It starts with adoptions, and I think it ends with probate. So that is the set of forms that you'll find. It's funny, people say adoption to zoning. That's the A to Z. That's all the law in the books. But this is the clerk of the circuit court website. Erin Cartwright Weinstein is the clerk. She's very nice, very helpful, and I think this website is really great. And again, you can find those forms here at the clerk's website. And just to show you what a couple of the forms look like, here's the petition. I don't know if you remember, but I said the petition is for probate and for letters. So petition for probate means to open up the probate estate, and for letters means letters of office, so that the administrator or executor can act on behalf of the estate. And one of the other documents I mentioned was this one, the affidavit of heirship, where you basically swear to the court who the heirs, who survives the decedent. So those are form documents, petition, and affidavit. Once the estate is open, you have to do several things. You have to marshal all the assets and address all the claims. And we'll talk about claims first, okay? So the claims notice after the estate is open. Once the estate is opened, you want to send a claims notice to known creditors to start the claims period clock ticking. There are two types of creditors. there's creditors that you know about, and then unknown creditors. Known creditors need actual notice that the decedent has passed away, and then they can come in and file a claim. Unknown creditors receive notice through publication. I don't know if you've seen this before, but in newspapers, there's a section of claim notices, and all the big banks and credit card companies scour that page to see who's passed away and basically to try and find out if they can make a claim. For unknown claims, this is really important. Creditors must file within 6 months. So if they don't file within 6 months, they're barred from making a claim. And even if they do file, you can fight it. You can fight it with a notice of disallowance. Then a hearing would come, and sometimes the creditor won't come, and the claim might be dismissed. Notices to heirs and legatees. You have to send notice of the order appointing the executor and administrator to heirs and legatees. You have to send notice of independent administration and testate estate to heirs and legatees. These are notices that you have to send out that are important to begin the process of administering the estate. So what happens in estate administration? It's pretty straightforward. You collect the assets, prepare the inventory, get a social security number for the estate from the IRS. Okay. You use that to set up a bank account for the estate, which is a checking account. And the inventory and the estate account, the checking account, kind of go together. The inventory consists of all the assets of the estate. And as money comes in and out of the estate, it should be accounted for in the bank account so that the heirs know what happened. Because at the end, you're going to have to, the executor is going to have to prepare an accounting for everything that came into the estate and went out. So again, collect the assets of the estate, get them all together, prepare an inventory of what they are, set up a bank account with the EIN from the IRS, do any tax returns that are necessary, pay the claims that are presented and have to be paid, prepare the accounting, and then do the final distribution. And that is what happens in estate administration. Then once that's done, you have to close the estate in court, and that's really the final step. You go to court to present the final closing papers. You show the judge receipts so that every beneficiary or every heir that got something from the estate has to sign off and say they got it. And one thing for the executor to do is to get the receipt before making the distribution. So you basically send a letter to the heir or the beneficiary legatee and say, hey, I have this check for you, it's all ready. I just need you to sign this, and then I'll send it as soon as I get the signed receipt. Otherwise, sometimes you can make a distribution and have a hard time getting that receipt signed. You also have to show the judge the proof of publication in the newspaper. And then the final report is something that informs the beneficiaries. It basically says that you've informed the beneficiaries that administration is complete and you've sent them an accounting. So that concludes my presentation, and I hope the procedures and the reasons and what probate is a little clearer now than when we started. So if you have time and interest, please fill out the seminar evaluation form and include any contact information for an appointment. And that evaluation form again can be found at http:// Lake Probate Seminar with hyphens there. So fox-lake-probate-seminar.paperform.co. So it's .co, it's not .com, it's .co. So I'll be here. I'll be waiting just a little bit to see if there are any questions. I'm happy to take them.